training session on rights requests and the requests for records of deceased. I'm Steve Durbin. I'm your DPO. If you haven't already met me, hello. Okay, but I am here. And as part of the role of the DPO, ensuring that people are maintained with training and aware of data protection issues is a very, very key thing. So we are recording this, which will be put on YouTube afterwards for other people to review and use. So if you do object to that, please PM me and I'll make sure that this recording is not used for that purpose. So what are we going to go through? Well, I will learn the objectives today. We've got 60 minutes. Okay, I'm hoping there's going to be 15 minutes of Q&A at the end of it. I won't record the Q&A. I'll stop recording at that point. Make sure you understand the data protection rights. Ensure you understand how things change at death, because it's a massive change in law when people die, and also provide a forum for questions, anything like that. In terms of outline, we're going to go through the general rights and principles, what we need to do for those, then the requested rights articles 12 through 22, the stuff about the deceased, a little bit on dealing with complaints and some learning experiences from that. I'm also going to talk about some forthcoming law changes, because there's a bill going through Parliament at the moment called the Data Use and Access Bill, and another one called the Investigative Power, it's gone through, called the Investigative Powers Amendment Act 2024, which make quite a big difference to what's happening with data in NHS and other areas. This is mostly focused on NHS, by the way, and it's England and Wales law only. Okay, I'm not discussing Scottish or Northern Irish law. Okay, so you've all seen the data protection principles. I think it's against the law for a DPO not to put all the data protection principles in any presentation. So we need to be very clear on those. Those give you actually general rights, as we call them. Okay, so these are rights which are effectively ones that come from the principles. So the fact we've got to be transparent and we've got to be explicit means we have to have privacy notices, even without Article 13. It's a requirement. Okay, we've got to tell people what we're doing with the data before we do it. So we've got to put it on forms, or we've got to put it on privacy notices wherever. Okay, and we can't change our minds and do something completely different afterwards because we felt like it. We have to make sure that we are doing things appropriately. Okay, the next three principles, okay, require that effectively we are making sure that people are kept up to date. We can't keep data that we don't need, and we've got to get rid of it, and we can only keep summaries of data. All that's laid out in the principles before you even start on the rights. And the last principle, Principle 6, says that we have to process in a manner that ensures appropriate security. So that means we have to keep people's data secure. Now, when we're dealing with health data, okay, that's very, very important. So we have to be very cautious about that. And you can and will get civil claims as well as regulator action if things go wrong. We get a lot of civil claims for data protection issues, and that's why it's so important. They're quite hard to defend if you've done it wrong. There's also a thing called the accountability principle. This is also in Article 5, where they lay out the principles, but this is paragraph 2, which basically says that you must be able to demonstrate compliance with this at any time. So effectively, the Information Commissioner, the regulator, can come in and say, right, I want all this information to show that you're doing it right. And you've got 1 week to produce it. So you can't retrofit this stuff. You have to have it ready and waiting, okay, and make sure it's all done for your patients. Okay, that's why I bang on about privacy notices and stuff like that all the time, because it's very, very important. They can also come in and do a mandatory inspection of you. That's very rare, but one of them was actually done in Enfield. Okay, it wasn't a GP practice, but it was a company called Doorstep Dispensary, who eventually ended up getting fined literally $500,000, more than that in the end, and it went bankrupt because of it. So bear in mind, they do enforce these rules when they want to. They have said they won't fine the public sector, but that's a guidance, not a rule. So just to summarize those general rights bits, okay, the principles require that we make sure that people are being transparent, that we're using things legitimately, that we're using the minimum data, that we're keeping things up to date only for as long as needed, and that we keep it secure, and that we can be inspected. Okay, so that's the general principles, which I did I always put those at the front just in case people don't know them. So now we're going to deep dive into each of the subject rights. Now, GDPR has got 99 articles, of which 10, 12 through 22, are actually ones about data subjects and their rights. So a large chunk of the Act is about the rights of people. So just bear that in mind. That's the list there. We're going to go through each of them in turn. Okay, and I'll talk in detail about Article 15, which is the one we get the most issues with, obviously, because that's the one where people give us a lot of requests. So, first of all, Article 12, we've got to provide information at the time that we we collect the data and at the time they exercise the rights. Okay, so we have to have on our forms, both paper and electronic, details of what we're going to do to include transparency. We need to have those published privacy notices. We also can't charge for providing information or exercising the right with some very minor exceptions. And we have to provide an accessible format. So if someone asks for your privacy notice in Braille, we have to print your privacy notice in Braille. Okay, bear that in mind. One thing that a lot of practices don't do well, and we are improving on this, but it's something that you need to be aware of, is we cannot stop people exercising rights or stand in their way. So having a required form they have to fill in is actually not legal. They can request a right by literally saying to you, I want my data. They don't have to fill in a form. You don't have to do anything else. People get this wrong. The only thing you have to do, and you're allowed to do that under one of the articles, is to identify them and confirm their identity. That's all we're allowed to do. Anything beyond that is obstructing the right and would not be allowed. Okay. We also can't, we need to publish contact details. It's why I try to make sure that the DPO email is on everyone's website, because it's important that it's there, because it's a legal right to request from me. Okay. The ICO talks about standard icons. Some organisations use them, some don't. It's never been really standardised in the UK, so it's not a big issue. Okay. We have to allow people to exercise the rights, and we have to provide without undue delay. Now, if you ask most people will say, oh, you've got 1 month to provide a subject access request or any other rights request. No, you haven't. You must provide it without undue delay and in any case within 1 calendar month. Okay, you can only extend that 1 calendar month by another 2 months if it's a really complicated request, or that's the reason why you absolutely have to. So one good example there would be you get a request from a parent who is not living with the child for all the records, and there's a lot of safeguarding and social care stuff, which you'd have to consult social care about releasing. That would be a reason for extending the period. Okay, but that should be the exception, not the rule. And in any case, we always provide as soon as we can. We don't wait for the end of the period. Okay. Any questions on Article 12? No. Okay, let's move on to Articles 13 and 14. This is the transparency stuff. Okay. Then the privacy notices and the rest of it. You have to provide people with information about what data you're holding. Article 13 and 14 are broadly the same. Article 13 is where the data came from the data subject. Article 14 is where you got it from someone else. But they're broadly the same, and you'll need one privacy notice. You don't need a separate one. We have to put in all of those details on there. Okay, every single one of them must legally be on there. People sometimes miss some of these. So you have to have the contact details of the DPO as well as practice contact details on there. Okay, we've got to have why we're doing it. We've got to have categories, all this in the standard privacy notice. But there's also things like the right to lodge a complaint. A lot of people, where their websites have been set up by third parties like Practice 365, have got the Practice 365 privacy notice, not the GP privacy notice. So you need to make sure it's linked clearly and people know about it. Okay, all of those pieces of information must be in there. If you're using my standard notices, you're fine, because everything is in there from those. Okay. Article 14 adds a few things that you have to say. Okay, so if we're getting the data from someone else, we've got to tell people why we got it, what a legitimate interest if we're using that. We don't generally use legitimate interest in healthcare. We tend to use public health or provision of health and care services. So that doesn't really apply to us. And where we got the data from, even if we scraped it off a public source. An awful lot of organisations miss this, and in particular, I would point out all the current AI systems are scraping data from loads of places. I've never yet seen one of them notify me where they got it from. So there you are. Okay. All information must be given before we start processing. We can't start processing until we've given them information. This is why you sometimes receive organisations Article 14 processing notice. They're telling you they're going to start processing your data. We can't generally use legitimate interest for keeping data, but we don't generally need to because we've got other legal bases. Be aware that when using websites, an awful lot of websites get this wrong in terms of what information they're providing and stuff like that. There's an awful lot of deceptive practice out there. The ICO is clamping down on it for UK sites, but with international sites, it's quite hard. Okay, now for the big one, the data subject access right. Woo! We all get totally excited about this because it's the one that causes the most time and effort for healthcare. Bear in mind, okay, that providing people with the NHS app is not fulfilling their Article 15 right. They're entitled to a copy of the data. The NHS app doesn't give them a copy of the data, it gives them access to it. So they can still request it even if they have the NHS app. Hopefully they're less likely to if they're using the NHS app. That was one of the things they were hoping was a benefit, but if they're not, well, that's tough. We have to answer it. Who can ask for data here? Okay, well, basically the data subject can ask, okay, the person themselves. A person with parental responsibility if they're under 18. Now, this gets a bit difficult because we have rules about the GILIT competency. If the child's over 11, we may have to actually consult the child. Okay, I'll talk about that in a bit more detail soon. A person with a lasting power of attorney or a deputyship, but only if they've got health powers over health and welfare, not if they've only got finance. I'll talk about that in more detail too. A solicitor instructed by the data subject and also litigation friend. Okay, and anyone to whom the data subject has clearly consented. We get this a lot with immigration cases where you've got people whose English isn't particularly good because they just come into the country. A lot of them appoint immigration advisors to help them with these things, who will then make subject access requests on behalf of the person because their English is better. Simple as that. We see it very commonly. It's not an issue. Bear in mind, okay, if the data subject is over 18, okay, you have a problem here. If they don't have an LPA or a deputyship, technically we should refuse because the person themselves cannot give consent and they're over 18, they're an adult. Now, we don't always refuse. What we will do is advise them to get a deputyship because obviously they can't get an LPA if the person's not competent. But that can cause issues and we have to be very careful with those. So it's always a good idea for anyone that's got a child with any issues which mean they're not competent to make sure they get a deputyship before they turn 18, but also for anyone who's losing mental capacity due to age, illness or whatever, or treatments, make sure they grant an LPA before that happens because otherwise no one can act on their behalf and it gets really complicated then. So what have we got to supply when someone makes a subject access request? Well, the first thing we've got to do is supply them with all the things in Article 13. So we're supposed to give them a copy of our privacy notice and all that sort of stuff at the same time. A lot of people don't. No one seems to get up on galloping horse to worry about it because the privacy notice is published, but technically we should always be including it. Just bear that in mind. We have to provide them with the data they requested, and they can say all data. We can't refuse that. They can ask for everything. We have to provide it in the form they requested. So normally we provide it electronically, but they can request it on paper. Okay. We can't charge unless the request is repeated or excessive. Now, what that means is if they ask it both on electronic and paper, we can charge for the paper and we can say, sorry, that, you're asking for it in both forms. That's excessive. You're going to pay us for one of those. If they only ask for it electronically, we can't. If they ask for it repeatedly, okay, so they ask for the same data more than once, we can again charge. We've got 1 calendar month to supply, as noted. Okay, now that means that it varies from 28 days up to 31. So if you get a data request in January, for example, okay, January the 28th, okay, you have to do that by February the 28th. So bear in mind that it can vary. It's not 30 days. It's not 20 working days. People get confused with other law here, but it is actually 1 calendar month. So there are exemptions to subject access right. We can take out data. Now, data we'd normally take out, okay, is data that would adversely affect the rights and freedoms of others. So commonly that's data about third parties. Okay, so for example, if mum had come in and told us that son was exhibiting severe mental health issues or something like that, okay, but she didn't expect us to tell him, just to actually ask him to come in so we could review him, then we can remove that data because that was given to us in confidence, for example. Okay. Generally, staff data in professional context is not exempt. So if your name is on the record as a person that did the review or issued the letter, okay, that stays. However, your email address, your mobile phone number, stuff like that can be removed. Okay, because that's your personal data. It's not your data acting in a professional capacity. We can sometimes remove things like appointment schedules, addresses of other parents if the children are at risk, stuff like that. Okay, so an example given at the bottom there, you know, you've got 2 parents separated. There's a known risk of domestic violence, and one parent is in a safe house with the child. If the other parent requests the records, we would not provide the address of the child or the fact they were coming in to see us on Wednesday, because that would put the child or the parent at risk, or the safe house for that matter. Okay. So that's the first lot of exemptions. There's a whole series of other exemptions, okay? And when I say series, okay, it's massive. It's 39 of them, okay? So we can remove stuff that's subject to other exemptions, okay? There's exemptions around crime and tax. We can disclose stuff as well. Anything cause serious harm, anything the data subject wouldn't expect us to disclose, some safeguard and child abuse data, self-incrimination, legal professional privilege, confidential reference, blah, 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 and it's a long, long list, okay? So bear in mind there are a huge number of exemptions. I'm happy to help you to remove data, okay, if you're not sure what to remove. I would point out that GDPR doesn't do this particularly well. Be very, very cautious using the free version of it. And the reason I say that is because it does it very mechanically and it doesn't pick up a lot of issues. So, for example, we had a disclosure of domestic potential accusation of domestic violence exposed to the person who was accused when it shouldn't have been, because the violence had been auto-corrected to violate. I kid you not. Okay, that caused a major court case. So we need to be quite careful using automated tools of any sort. Okay. I'm not the Department of No, I'm not telling you not to use them. I'm just saying you need to be careful. So how do we deal with Article 15 requests? Well, I suggest this mechanism, okay, where you follow the 6 R's, okay? I like my acronyms, makes things easier to remember for me. So we receive the request, we check what they're asking for. Sorry about the monkey covering the floor there, and acknowledge. The clock doesn't start until you have clear clarity on their right of access and their identity. Okay, that's when the clock starts in terms of the 1 calendar month. You can't delay though by leaving it. So if you get a request on day 1, okay, you have only really got day 2 to ask them to prove their identity. Okay, you can't leave it till day 30 and go, oh, you haven't proved your identity, the clock starts now. Can't do that. Okay. And also, if you can see straight away this is going to be a really complicated or big one, it's worth telling them as soon as possible you're going to have to extend the deadline. Otherwise, it looks like you've extended the deadline because you haven't done the work. If we tell them early, that makes it very clear to them. We looked at it and went, oh, this is going to be too big, and we'll have to extend the deadline. Okay, record the request for tracking. Okay, I've got a spreadsheet for this if you haven't got a system. A lot of people record it in the patient record. There may be a requirement before long to actually provide numbers of requests and stuff like that to the ICO. There's some stuff in law that's going through Parliament at the moment that may get changed to include that. Round it all up. Round up all the data, okay, even the data you think you're not going to reveal, put it all in one place and keep it. Now, the reason you have to do that is partly because the NHS mandates it in the Record Management Code of Conduct, but also because it makes life so much easier if there's an appeal. So we put it all in one place, okay, and then we've got it there ready for review. It's a good idea to also convert it to one format. Converting everything to PDF, for example, is a great way of making sure that the person receiving it can read the data. We quite often get things like 111 calls coming out as XML files and stuff like that, which of course the patients can't then read. Convert everything to PDF is the preference. When you've got it in place, you need to redact it, remove the information that with using whatever tool you're going to use. I'll talk about that in a bit more detail shortly. Okay, and we need to record those redactions and why we did them. That's because it can be appealed. And then we respond, we send it to them. And then we need to keep our response, okay, and the data we use to create it for 3 years. That's the minimum. It's 6 years if it's appealed to the ICO. That's in the NHS Records Management Code of Conduct. So keep these things separately. And a great way of doing it, it's what I do anyway when I'm doing them, okay, is just to keep them in files by year. So you can effectively, at the end of 2025, you know you can delete anything that goes back to goes back 6 years, that sort of thing. Okay, so we've mentioned redaction. How do we do redaction? So we have to do it where it's legally required. We can't redact things that are embarrassing. The exemptions I mentioned earlier. We can redact for some harm, as long as they're serious ones. We can redact if we've broken the law, but I wouldn't recommend that because it's going to come out anyway, so probably just leave it in there. We have to record what exemptions we use. We don't necessarily tell the data subject because a lot of the redactions actually have a thing there saying they're not entitled to the information about why you redacted, but we do have to tell the ICO if they ask. So that's why I've got that lovely SAR redactions workbook that you're very welcome to record what we redacted and why. And so always keep the original and redacted version because you may well need it. And if the patient's moved on, you may not now have the full records if it is appealed. So how do you physically redact? Well, you can use whiteout and stuff like that, Tipex, these sort of things, and then rescan. Okay, you can use black marker and then rescan. You can please check physical methods under strong light because things can be more readable than you think they are. If you're using something like Adobe to redact, okay, or Word or whatever, please be aware that just changing the font color doesn't work because all the metadata, like the accessibility information for screen readers and stuff, gets left behind even if they can't change it back. And if you can edit the PDF, which there are 3 tools available for, that is trivially easy if all you've done is change the font color. Adobe Acrobat has got built into it the ability to properly redact things and remove all hidden information. That is great, it's very useful, but it's not cheap. I haven't come across any other tools for PDFs that do it as well as Adobe, so it's one of those things where you're putting a rock in a hard place. You're talking something like £30 a month for the license for it. Okay. There have been many, many data breaches because people didn't remove hidden data, including the UK government releasing full details of secret agents because they had a PDF, they redacted it by changing the color, and of course all the information was still there. Okay, people make mistakes, be careful. Okay, so we're going to look at some challenges now. Okay, one common challenge is with children. So as children get older, obviously, they have rights to privacy like everyone else, okay, and those rights will become stronger as they get older. The general rule is that any child who is GILIC competent must be consulted on subject access requests made in their name or any other request for that matter. It's always the child's data, no matter what the child's age, okay, so that applies across the board. In Scotland, they've defined 13 years old as being the age at which you will do it. NHS guidance says we must ask them and determine if they get it competent from 11 upwards. Okay, so it's not absolute. You have to assess the child's competence, whether or not they understand the consequence of saying no and stuff like that. That can be incredibly difficult in more parent situations. So each parent's got the right to the child's data, okay, unless that's their parental responsibility removed by record. That is vanishingly rare. They practically never do that. Even if they forbid access to one of the birth parents, okay, they are still allowed to request data. So we have to follow the redaction rules very carefully. Be careful not to give the parent information that could be used against the other one. Okay. And if someone claims that a parent's got no parental rights, we need proof. There will be a document for that from the family court. Okay, so be very clear about that. As I mentioned earlier, adult children lack competence. It's a real problem. Okay, we can't provide things under Article 15 without deputyship or a LPA. And that must be for health and welfare, not just for finance. Now, I'm saying that as an absolute because that's what the law says. Okay, however, we can take the person's best interest into account as we can in other decisions. But we have to be very careful to make sure we're documenting that. We're absolutely clear on why we're doing it. Okay. You often say people say, "Oh, I've got access because they're next of kin." The data protection law does not mention that next of kin anywhere. Not the next of kin has got a unique definition anyway. So there are no rights for next of kin. Full stop. Okay. Anyone that just says next of kin, you can ignore it completely because there is no right for next of kin. So if people haven't got deputy or lasting power of attorney, it can be a real challenge. Litigation friends can have data related to the case. So if a litigation friend's been appointed, they can have data related to the case. They still can't have the whole medical record, just relevant to the case. So third lot of common challenges, one we often get from staff is them asking for references because you gave them bad reference. Good news, references are completely exempt. Okay, we do not have to provide references if they were given us confidential references. End of story. Okay. We also get a lot of issues with personal injury claims and solicitors. They invariably try to get the whole medical record because it saves them money by using subject access request. They don't have to pay us for a medical report. They've been doing that ever since the Act came in. So we need to make sure the data subject is aware that we're going to be giving them too much information. Okay, because they don't need all that information for their report, but they will always ask for it and demand it. Okay, they will also lie to you about how long the deadline is. They'll say things like 20 days and stuff like that. It's wrong. Okay, they're terrible for this. There is a standard law society form, law society BMA form agreed years ago, which covers all the things that the person needs to be told and has a signature box for the solicitor to say they've told them all this stuff. Okay, so if they haven't given you that form, okay, you can ask the patient directly, or you can say to them, please provide this on the standard form so I know you've told the patient. Okay, so that's it on Article 15, the big one. So just remember those 6 R's, because that's a good way of doing it. I will be sending the slides out afterwards. Don't worry, you don't need to write this all down. Okay. Please consult me on redactions and complicated cases. It's far easier to fix it before we issue it than afterwards. Okay. We need to look at children when if they're older children, when we get records requests from the parents. Okay, and records for the deceased are not subject access requests. I'll be covering that in a lot more detail later on. So any questions on Article 15 before we move on? No. Okay, lovely. Thank you. So let's move on to Article 16, which is the right to rectification. Now, the data subject can't ask you to falsify the record. Let's be absolutely clear on this. If they say, I want my diagnosis of drug addiction removed or corrected to not say that, that's falsification. You can't do it. Okay, so we can only really rectify errors, and even then we have to be very clear on the error. So a incorrect diagnosis on a record is not an error. It's an incorrect diagnosis. We can't generally change those because somebody will have used that diagnosis later on. So, for example, it's fairly common for people with certain kinds of personality disorder to be diagnosed as being schizophrenic. Okay, that would be on their records. We can't remove that, but we can add a note to it saying this diagnosis was later proved incorrect. Okay, but it's the same timescale as all the other rights. So all we can do is generally add notes. We can't generally remove, rectify things by changing them because it's falsifying the medical record. The next right is broadly similar. It's the right to erasure. Okay, no, it's got nothing to do with these bans. Okay, this is often called right to be forgotten. Okay, it's incredibly rare. It applies to medical records. Okay, the data must no longer be needed. Okay, it's if it was given by consent, then we have to remove it. We never use consent as a legal basis. This is one of the reasons we don't. Okay, there's an objection to process. We got no legal grounds. That's anywhere as well. Legal obligations to erase are incredibly rare, and we don't do information society service. You can forget that one. Okay, if we have to erase something, we have to tell everyone else we've shared the data with that we're erasing it, so they can erase it too. So bear that in mind, okay, when you're sharing data. You need proper sharing records, because otherwise that can be quite challenging. That's why we have sharing agreements. So we know we might have told these other people, and therefore we can tell them. There's certain exemptions as well for freedom of expression, legal obligations, public interest, and so on and so forth. Okay, same time scale as the other rights. Okay, it is vanishingly rare that this will ever happen with medical records. People can't ask for their medical records to be, well, they can ask, we'll just say no. We can't delete people's medical records because, of course, we have that legal claims obligation. We might get a medical claim later on. Okay, that would result in us needing the record, so we can't erase them. We also can't erase them because we're required by law, the NHS Act, in fact, to retain patient records. End of story. Even if someone's moving abroad and want all their records erased, we never do it. Feel free to come to me with these and I can give you clarity on them, but effectively that right practically never applies. I think we've had 2 cases in the 8 years I've been doing this now that apply to medical records. The next right is restriction of processing. Okay, so that means the data subject can just say, stop, I'm not allowing any further processing. Sorry, I saw a hand go up then. Pooja?
Yeah, sorry, it was just with the previous slide that we had. I had a patient, 55 years old lady, who asked me to give her records, taking away all her gynae things. Is that something that we should be taking, or we can say them no, or?
Okay, so let's be clear on what we're saying here. Sorry, I've just accidentally muted my speaker, so I can't hear you a second. One moment. It's not your fault. It's mine. My speakers tend to be a bit awkward. Right. Okay, that's better. So basically, what happens here is that if we are providing information under Article 15 to the patient, okay, they can request whatever they want from the record. It doesn't have to be the whole record. If they're requesting records for a legal purpose, okay, so for example, someone is joining the army and the army's requested the medical records for that, we can't remove things from that because that's falsification. We're lying to someone else about what's in the record.
Yeah.
Okay, so we have to be very, very cautious on that.
But with the legal matter, we can, yeah.
Yeah, but with a legal matter, if the challenge would really be whether or not it's relevant to the legal matter. If it's not relevant to the legal matter, probably not. If say she was doing a personal accident claim and she didn't want the data in there about her gynae stuff because it's not relevant to personal accident, perfectly reasonable. Okay, but I would point out that the accident company should not be requesting full records in the first place, which is what I said previously, but they always do.
Yeah.
And the reason is mostly because they're looking for exceptions, so they can not pay out. Insurance companies do it as well. Okay. So does that answer your question? Yeah.
Yeah. Lovely.
Thank you. Okay. Right. Okay. So Article 18, restriction of processing. Basically, they can ask us to stop processing for those 4 reasons. Okay. It's again incredibly rare. If you get one of these, please contact me. But it's very, very unlikely we're ever going to do that. Okay. Article 19 is a bit of a weirdie, okay, because Article 19 is basically just saying if you're doing things under 16, 17, and 18, you have to tell people you're doing it, okay, which is fairly obvious, but it's actually a specific article, okay. You've got to notify all the recipients of that data of what's happening, and you've also got to notify anybody who asks, so the data subject can be told about those recipients. One reason why the record keeping so important about these things. Article 20 is a right to data portability. That means you must be able to have your data in a structured, commonly used machine readable format to take to some other provider. Now, that only applies if it's applied for consent or for contract purposes. And basically, the idea here is to allow people to move between social media providers and stuff like that. That's what it's for. Okay. It doesn't apply to public task uses, and all our uses should be under public task, with the exception of research, which is consent-based. But it's one reason why when people talk about consent, I'm always very clear. We're not processing on the basis of consent. We're processing on the basis of public task for healthcare. So, for example, with all the new AI systems, we're going to be recording people in their on their telephone calls and when they're having consultations, so that we can pass it through the AI to allow us to do summarization. That does not require a consent. It requires us to inform them that we're doing it, and they have a right to object, which we'll come to in a second. Okay, they do not have it's not a consent. So I always ask people to be very careful what they're phrasing here, because it isn't a consent and it can confuse people. We do not do things by consent. Yes, I know there's NHS documentation saying we do things by consent. It's out of date and hasn't been properly revised, and it does drive me nuts that, you know, literally, where are we? 7 years after the regulations came in, they still haven't updated these things. So let's talk about the right to object then. Okay, so effectively, there's the ability to say to us, I want you to stop processing my data. I object to your use of the data. That does apply to us because we're using public task, so we have to do it. Okay. Now, what we have to do here is we have to demonstrate that we have a compelling, legitimate interest in using their data. Okay, and that our needs override their rights. Now, because we're doing public task, we're required to, by law, we're required to maintain medical records, and we can be sued if we haven't got them. Then, you know, we have got a clear legitimate interest, and I've got a standard template for these, because whenever these come in, we literally just give them the template and say, sorry, we're not doing that. Okay, there's a very specific form we've got to do this in, so please ask me about that, because otherwise, if you just say no, I'm not allowing it, the ICO will come down and you'll get a rectangular building things and say you didn't explain it properly. Okay, Article 22 is the requirement not to be subject to automated decision making. Okay, this is very, very important. Okay, because you can't subject people to automated decision making if there are if it has legal consequences for them. Okay, we can only use data for automated decision making and profiling if there's been an explicit consent, which we don't want to use, because if we do that, then all the other consent things come in and we don't want to go there. Okay, if it's necessary, or if there's reasons for doing it. This is coming up a lot in AI stuff now. Okay, to be clear, this is one of the reasons why I keep banging on about GPs reviewing the stuff the AI is producing before it goes into the record, because if we got that human review in place, it's not automated decision making. If it is, we have to make sure we cover this and we're not infringing people's rights. So that's very, very important. All the DPIAs I've done for the AI stuff have got this in as a specific point. It's one of the reasons we have to be very clear with what we're doing. So that's pretty much all the rights. Okay, so bear in mind, rights don't have to be requested in writing. I've mentioned that a couple of times. Okay, and we need to make sure that all staff are aware of that, because if somebody literally says to your receptionist, I want all my data, that's a subject right. You now have to deal with it. It's been notified to a member of staff. You can't just say, oh, we'll fill in this form then. Okay, or you need to talk to X. Okay, it needs to be actioned. They're rights, not privileges. We can't stand in the way of them. Okay, timescale I mentioned 1 calendar month, but can be extended, but that's a limit. It's not a target. Okay, remember that all the rights of exemptions that we can use to protect other people, that comes up a lot. And if you're doing a data subject access request, it will do. And be very, very cautious about any automated processing, especially AIs. Talk to me about them first. Review the DPIAs I've done and make sure you've taken the appropriate risk things. So that's the end of the subject rights. Anything on that before we move on to the deceased records? Nope. Okay, thank you. Right, so subject rights summary for deceased. Basically, all the stuff I've just mentioned does not apply. Not one of those rights applies. As soon as you die, okay, you lose all those rights. Deceased people do not have those data protection rights. Please, please, please explain this to solicitors, okay, when they call you, because those solicitors always seem to think they do. I've never quite worked out why, but they do, okay. So if someone makes a subject access request for a deceased person, it's not a subject access request because it's not covered by that law. Okay, medical records of the deceased are covered by a thing called the Access to Health Records Act 1990. But the only people that have access on that are people making a claim on the estate, and only for information relevant to that claim. They can't make a request for anything outside of that. So they can't ask for the whole records unless, say, some very, very individual circumstances, like a young child dies and they're accused of hospital negligence, something like that. Then possibly, but it's very, very rare. Okay, there's also a new one that went in last year on this, which is that the coroner now has full rights. We've always given the coroner records anyway, but there wasn't actually a right to do it. We were always doing that under a sort of public task exemption. We now have formal things saying yes, we can. Okay, without that, okay, without using the Access to Health Records Act, it goes back to the common law duty of confidentiality, and there's an awful lot of case law on that we then have to involve. So please consult, okay, if you're not absolutely clear. So what law applies here? It's these two paragraphs of the Access to Health Records Act, Section 3, Paragraph 1, okay, which says that basically the only people that can ask for part of a health record is when the patient has died, the patient's personal representative. That basically means their executor, but kind of slightly different meetings, or any person who's got a claim. So bear in mind, it doesn't even have to be a relative here. It could be a company with an insurance claim against them and stuff like that. Okay, so it doesn't have to be a relative of any sort. But Section 5 of the same Act restricts what you can provide, okay, to things that are relevant to the claim. And that's in our opinion, not their opinion. Okay, so it's our decision to make. Yes, we can discuss it with them, and we're very happy to do that. Okay, but it's our decision, okay, as to what is relevant. So most solicitors seem to be strangely or possibly willfully ignorant of this law. The number of times we get a data subject access request to someone that's dead is so frequent that I've even got a template letter I just send out for it now because there are just so many of them. We get an average of 5 or 6 a month, more in January, February. You know, it's really, really weird that they don't seem to understand this and never seem to do. Okay. Just bear in mind, okay, think about it from your point of view as an individual. How would you feel about your kids having your medical records after your death? There's an awful lot of stuff we wouldn't want to see our kids to see. Terminations, STIs, okay, mental health issues, lots of things, okay? So it's restricted for a good reason, the dignity of the deceased. Okay, we're not just making this stuff up. Okay. Bear in mind that you need to know here if there's a claim against the practice. So always ask if they haven't said that there isn't a claim, okay, whether or not there is a claim, because you'll have to involve the MDU or your liability insurers at that point, because we can't start communicating with them until we're clear on that. Okay. Judging what's relevant to the claim can be very, very challenging. Okay, and we can have a lot of argument back and forth on that. I'm very happy to help provide an independent opinion on that. And of course, then if it does go pear-shaped, then if our decision is revoked, okay, it's partly my fault. So it helps you. Okay, we can be required by a court to produce the full records. That's vanishingly rare. I've seen it once in, well, over many years of practice. Okay, more than I care to count there. Okay, so that's all about records of the deceased. It's really that simple. Okay, I know people think it's complicated, but it really is that simple. So are there any questions on that? No? Okay, well, we're always bang on time. I'm just going to talk briefly about dealing with complaints. Okay, please be aware that all complaints can go to the Information Commissioner, so we need procedures. If you haven't got internal procedures, okay, those procedures must include the fact that you can complain to the ICO and reflect that the timescales may be different to your normal complaints procedure. Okay. Please be aware that complaints about data often need careful handling. Okay. Please don't tell them how they should feel. Ask them how they feel. Stuff like that. Okay. Try to be not legalistic where you can. Some people just have to be legalistic and they won't listen otherwise. But we try and be as calm and responsible as we can. All this stuff. You're all good at handling complaints. Okay. But bear it in mind, data can be very sensitive, especially data where people think it's wrong. Okay, and please don't respond to the ICO or anyone without consulting me first. Okay, we have had several cases where practices have responded to the ICO incorrectly, and we've ended up really on the back foot, and one practice narrowly escaped getting an enforcement notice on the basis of it. So please don't do that. Okay, make sure that I've been consulted on it if you think there may be any risks in there. I banged on about data protection officers a lot. Okay, what do we do? Well, this is our job. Okay, we're the lightning rods. Okay, we're the people that if you've consulted us, you've got a degree of liability removed from you because we have to deal with it. We apply the independent review and audit to you. Okay, we make sure that you're doing things right and advise you on it. Critical friend sort of thing. We act as the interface between the regulator and the public. The regulator come to us direct and can the public, so we can deal with that stroppy patient if you really want us to. Okay, and we advise you. Okay, we let you know things that are going on. We try and ensure you're properly trained. We try and ensure that you know what you need to do. Okay, so before we end, I just wanted to point out some law changes that are coming up. Okay, this is in the data use and access and the investigatory powers bills currently going through Parliament. These things are quite significant for us, but we don't know if it's going to become law yet. It's likely to in the next few months. Basically, consent for research is now general. So if you consented to one lot of research, you consented to all research being done with your data. That's a surprising one. Okay. You're generally now allowed to do research, archiving, and statistics processing. Okay, fine. It's a general allowed purpose. That's great. That makes life easier for us. Processing to curate anonymous statistics is now allowed. Now, previously, we needed a Section 251 from order from the Secretary of State to do that. NCL has got one for all the stuff it does with healthy intent, for example. Okay, now that much reduces that because if we're doing research, archiving, statistics, it's just allowed. Okay. There's going to be a requirement to tell the ICO how many breaches and complaints we've received. So we need to make sure we're recording those or we can search them easily. That probably won't commence for another year, but we need to start thinking about it now. Okay. One really big and important but useful change is that we can now disclose things to courts without it being part of what's called discovery. So it doesn't get shown to the lawyers on each side. It only gets shown to the court. This is incredibly important in things like child protection cases, where quite often there's one person being accused of abuse. You don't want the other person to see that as part of the child case, okay, because it's not part of their discovery. We can now disclose to the court everything the court needs to know, and the court can then make the decisions. That's a really useful change. Really pleased with that one. They've also limited the Article 15 right, okay, the subject access right, to a reasonable search of your data. So this gets away from, if you're keeping huge numbers of paper records and stuff like that, you don't have to go digging through all the filing cabinets and stuff. Not sure that one's going to pan out, but it looks positive overall. Slightly more negatively, okay, they've reduced our cookie rights a lot, so effectively you can't object to certain cookies now, and direct marketing by charities by email is now fully allowed, and they can all share your data with other charities, so you expect a lot more charity spam. They've reduced rights on automated processing. That's because of AI. They're trying to make sure we can do AI more easily. That'll help us where we're using AI, but for all of us as individuals, it's a reduction in our rights and it's a protection being removed. The Secretary of State for Health and Social Care now has a new power which allows them to dictate information systems as well as information standards. So that could mean they're going to dictate a UK-wide NHS data pool, which the Sutherland report recommended. It could mean they're going to say to us, you're all going to use this system over here and you haven't got any choice about putting your data in it. Okay, don't know how that's going to work out yet. It's a power. It doesn't say in the Act what they're going to do with it. There's also the ability for the intelligence services to require access to systems. That was passed last year, but it's only just really become a big issue with Apple accidentally, of course, revealing that they'd had one of these so-called enforcement notices. Okay, the thing's called technical provision notices, where they're allowed to force people to not have backdoor, not have end-to-end encryption, so they can backdoor systems, and they can also take now what's called bulk personal data sets. That means basically they can suck up any data they want within reason. Okay, they can't suck up the whole of the NHS data, but they can certainly suck up the whole of the PDS, for example, if they wanted to. Okay, so there you are. It's 20 past, so we're just about in time. So, a summary here. Rights for living and deceased people are completely different. Please don't forget that. Okay, they're completely different. The only thing that applies generally to deceased records, aside from courts, is the Access to Health Records Act 1990. For living people, we've got to be very clear to be transparent. We've got to make sure we deal with the rights request within the timescale, and we can't prevent or stand in the way of rights. I'll come to your question in a second, Michelle. For deceased people, the coroner can now have the whole record. They always did, really. Okay, and for others, we can only provide where it's relevant to a claim on the estate, and there can be court orders. And don't forget, those changes are coming that I had in the last slide. Be aware of that. Okay, and I'm very happy to assist and advise. So there you go. So we'll now take questions. So I'll start off with,